cases in front of us this morning, and the first one looks like it is State of Ohio versus Koudelka. And I assume both sides are ready to proceed since you're both here bright and early and chipper.
That's correct, Your Honor.
All right. You know we videotape, right? So please stand behind the podium there and keep your voices up. And I'm just going to say this with every case because I don't want to forget, because I don't preside that much anymore. So make sure that you don't use victims' names, and if you use any for a child's name or anything like that. Okay? You can refer to them as a child or the victim or by initials. Thank you. And you will have 15 minutes, and you may reserve up to 5. Just let me know. Thank you.
Thank you, Your Honor. May it please the court, counsel, Attorney Kimberly Stout-Shear on behalf of Mario Koudelka. To give you some back.
Do you want to reserve any time?
Your Honor, I do wish to reserve 2 minutes.
Okay, sounds good. Thank you.
Thank you. To give you some background, Mr. Koudelka originally had divorced in 2005. He was at that time put under a support order to pay child support for his minor son consistently with that. Payments were eventually lowered in 2006. He had made some payments, however, there has been some spurts of unemployment, housing issues, and a lot of things that presented some obstacles for him. He did go to trial. Unfortunately, the court here had found him guilty of all 3 counts. We at this point believe that the trial court did err when it ruled that sufficient evidence existed to send that case to the jury. At the time, the criminal rule 29 had been stood, in which under that rule there should be an order, and the court can order if the evidence is insufficient to sustain that conviction at that time. Under those standards, and under that de novo standard that this court holds so true, we do not believe that that evidence, from viewing that evidence in light of it, the most favorable to prosecution, any rational trier of fact could have found that those essential elements of the crime had been proven beyond a reasonable doubt. At that time, they were unable to prove that, in fact, his mens rea was reckless. Because, and as held under the State v. Collins case of 89 Ohio State 3524, the proper mens rea in this offense has to be recklessness. Since that is not, there is no required mental state for that violation of Ohio Revised Code 2919-21, which is what he was charged with for that felony non-support.
Counsel, but evidently from what I read in the briefs, your client doesn't have any physical disabilities or mental disabilities, right?
He does not, Your Honor.
Okay, so how could that not at least show recklessness? Because he was living with family members for a while. It seems to me like he could have gotten a job at a fast food restaurant or something and just had enough to pay, what was it, like $150 a month?
I understand and take note of your point with it. However, under the Lindsay versus Summit County Children's Services Board, they've said that the actor must be conscious that his conduct will in all probability result in any injury. Based on that, he was trying, it's not that he was consciously trying to avoid payment. In that respect, what we're doing is you're punishing someone who has that inability. He was actively seeking work, actively working to try to find, going on interviews, trying to do whatever he could. He was living on the streets.
Did he indicate where he applied, what kind of jobs?
He indicated throughout the testimony that there was over 100 places that he applied throughout the course of he did not provide specifics with it other than there was multiple places that he had gone in interviews. He also had indicated that when he was extradited from Texas, he had a job lined up at the time, and unfortunately because he had been extradited, he had lost that job here in the U.S. Additionally, though, he had additional jobs where he'd been teaching in China and South Korea. Unfortunately, due to financial constraints, and things with that because the child support had not started to be coming here. The visa had been denied for renewal.
Well, what was his training experience? He's teaching English. What's his educational background?
His education is a bachelor's in sociology. He did receive that. He has had, based on that, his background was teaching English. Multiple employment had included teaching it overseas, and had worked in South Korea and China. He had been working actively with the agencies trying to get another job and get cleared with the visa to return. However, based on the child support and the limitations with that, they would not permit him to renew his visa.
What are we to take of the fact that if this doesn't show reckless, how are we supposed to take the fact that he wrote the letters and contacted his former spouse and said, if I'm willing to give up rights to my son if you just let me go with the child support?
Some of that, based on that with it, and based on what was some of the testimony with that, that was not his full intention. What the intention was that I need to get something. I need to get my employment. I need to get some communication. He hadn't had communication with his son. Obviously, that does not negate his ability to pay that child support or to do anything with that. But obviously, he was trying to work within his ability and within his means. They were very limited. He was in and out of the Haven Arrest when he was in Ohio, in Akron. He was in and out of other homeless shelters, helping from churches. Churches, he had exhausted all means with that, to where they kept bouncing him from church to church, and they could not continue to help him because at some point it was that you need to be able to get a job or get something. He kept trying. He kept applying everywhere, family attempted to make some payments for him, and they did make 2 payments for him. Unfortunately, that wasn't sufficient to bring him up to be in compliance with it. But punishing someone who was down on their luck or unable to even financially support themselves, given that he was living on the streets and on the sidewalk and sleeping with that, is detrimental with that. Because at that point, then we're trying to criminalize and to lock up someone because they can't afford the shirt that's on their back or the food that they are.
Did he have any mental health issues that prevented him from doing any of that? Was any evidence of that presented at all?
There was not any diagnosed mental health issues or anything with that nature. He just unfortunately was one who got caught with the system and with that. As he continued residing in those homeless shelters, unfortunately it created that stigma. As you go to the employer, the home address that you're putting on there is a homeless shelter.
Would he have otherwise was there any evidence that he applied for any sort of public assistance during these times that he was unemployed?
There was no evidence of any public assistance or anything with that.
And what about substance abuse? Any evidence?
There was no evidence of substance abuse. And frankly, some of the homeless shelters and some of the things that they had restrictions that he was placed into, that you weren't permitted to use any of those substances, or you would have been kicked out and not be able to receive some of those food benefits and some of the help with that. So he obviously did not have those issues, or they would not have allowed him to reside in there temporarily. As one distinction that we can say is because this court had upheld in the State v. Rhodes case in 2002 that this court had rejected any appellant's claim that the inability to pay was due to them losing their employment. But how that differs from this case is in that case, the appellant was a doctor. He lost his license, was unable to maintain his medical practice, but also continued and had large amounts of cash that were hoarded and that were resided and was able to provide and would give his children minor things and would things with that. He still had those means and financial means that was there. So he wasn't at a complete loss of ability. In this case, Mr. Koudelka didn't even have $5 to his name. At one point, Haven Arrest, a stranger showed up there and was handing out $5, $10 to residents. At some point, he got $5. That was it. That was his entire income. It was to the point of, does he get a meal? Because at Haven Arrest, you're only permitted there at night? Or does he come down here, which he doesn't even have the means to get from Akron to Medina with that $5? That could get him the bus ride here, but not return. At some point, he was using that $5 trying to get the meal, try to clean his clothes, trying to get himself to where he could go to an interview, try to get a job, and to make something better so that he could get himself back into. I believe at this point that there has been a substantial, and based on that ruling, that puts it puts a punishing effect. So we are punishing someone who can't physically afford, who can't keep a roof over their own head, who can't even maintain a car, or have clean clothes on their back, or food, and yet they're being punished with a criminal offense when they have no ability to pay that.
I can't remember now. Where was he residing in Texas?
He was originally down in Waco. He went
Did
back to
Was he
Waco.
with a relative or a friend or something?
Originally, he was in Indiana with a nephew. The nephew allowed him to stay there temporarily. The nephew ended up, because he could not find employment, he had to leave his nephew's home. He went into a homeless shelter because the nephew could not financially support both of them. He went into a homeless shelter from there. At that point, the homeless shelter, because there was such a stigma with the address and things with it, he was trying to create some addresses and trying to create something to get a job. So there was times when he would sleep on a park bench, there was times he would sleep on the concrete, anything to try to make it appear as if he had some stable, or present himself in a better light.
But that was in Indiana.
That was in Indiana.
Texas.
At some point, he then moved to Texas and was attempting to find a job, had found a job down there. When he moved to Texas, that was with an aunt who was willing to allow him to live there temporarily, provided he could find employment.
What kind of job was he looking for?
He was looking for teaching the English, and that's originally what was lined up down there. There was a substantial shortage of teachers down in Texas. They were willing to hire him with immigrants and to hire him in order to teach the English language.
So he couldn't find a job in his area of education.
He could not, and he had attempted to try to find a job, fast food places, anywhere that he could get an employment, and was unable to.
But did he testify, and that was there evidence that?
He testified that he had applied to many, many, many places, not just limited to strictly the.
I understand, but that was one of the first questions I asked you about the fast food places, and I thought you had responded that he had not specifically said where he had applied.
There have been some testimony, he didn't specify that there was fast food places. There have been some testimony that have been asked on cross-examination as to whether or not he had applied with any fast food.
Oh.
The answer that had been responded from the cross-examination was that it wasn't specifically yes or no with that. What the answer was that there was many, many places that he had attempted.
And you're in your rebuttal time.
Thank you.
Good morning. Morning, Your Honors, and may it please the Court, I'm Vince Vellucci with the Medina County Prosecutor's Office for the appellee, the State of Ohio. I will start with sufficiency argument, assignment of error 1. I'll just start with the fact that Koudelka does not dispute most of the elements of this non-support crime. He didn't dispute he's the child's father. He acknowledged that he knew about his obligation to support his child. He acknowledged that he failed to meet that obligation for 3 different periods of 26 weeks out of 104 consecutive weeks. The question that's been raised is of the recklessness on his part. The state of Ohio presented significant evidence to support that mens rea, especially in light of the Collins case that was mentioned. That's the Supreme Court of Ohio case, and that really is what lays out the standard for this. There, the court held that in a non-support case, a defendant's reckless mental state can be inferred from the fact that he was obligated to support his child and failed to do so over a significant period of time. Now, that's a simplistic way of putting it. What they actually said was more compelling than that. The court actually said, and I'll quote, "Where after notice and opportunity to be heard, a court order is issued mandating a person to submit child support payments to a specific agency of government, and that agency shows no record of any payments having been received from that person over a period of many years, a circumstantial inference arises that the person was aware of the obligation to pay and yet did not do so. Where no payments reached the agency over a period of many years, it may be inferred that the obligor took no action to ensure payment and in fact intended not to pay. Accordingly, where no evidence is presented to counter that inference, such as evidence of mistake or misdirected payments, a jury has evidence before it sufficient to establish a culpable mental state of at least recklessness beyond a reasonable doubt." So, in fact, they say even intent can be inferred, let alone recklessness, from just those bare facts alone.
Counsel, assuming there is sufficient evidence of recklessness, what about the affirmative defense?
The affirmative defense is interesting, and I had to research a lot of these cases because, and I know the Roders case was just mentioned, that came out of this court specifically. That's an interesting case, and I cite a few different districts that considered this defense, and in all of those cases I cite the court upheld the jury rejecting that affirmative defense, which essentially it says the affirmative defense is that the accused was unable to provide the established support but did provide the support that was within the accused's ability and means. So that's what this 2919-21D says. The Roders case is interesting because actually it was brought up about alcoholism. Was there an alcohol issue or a substance abuse issue? In this case, there was not any evidence of that in this case. The Roders case, there was evidence of that there was a problem with alcohol. Roders actually had two psychiatrists testify on his behalf. They talked about having diagnosed him as bipolar, manic depressive, even after taking medication. There was another psychiatrist who actually testified that he was psychotic, depressed, confused, and in his opinion, he said that Roders was functionally disabled. So we had absolutely nothing like that in this case, nothing whatsoever. But even in that case, they found that that was not enough to prove this defense.
Counsel, those facts can cut both ways, though, can they not? Because, here's somebody that doesn't have at least no evidence of addiction problem, substance abuse problem. And then you have individuals that do have substance abuse problems, and they afford, that's been used against them before because they can afford to get their alcohol or they get their drugs or whatever. So then we're like, well, if you can get alcohol and drugs, you can support your child. So it seems like, sometimes you're caught in a catch-22 with that, And with that case, isn't it true, though, that he did have cash in your Roders case?
Well, he was a doctor in that case.
He had some means of support. I mean, even if it was a sell his house or something. Here's an individual that the testimony basically is unrefuted that he was homeless a lot of the time.
Well, I don't think a lot of the time. There was, like we mentioned, the time in Texas, he was staying with an aunt. And I think it's interesting, not only was they had a place to live with his aunt during that time, he even admitted that when he was in Texas with his aunt, she was willing to provide him with a vehicle. And Koudelka testified he intended to switch his Ohio license to a Texas license, never did that. That was his own negligence that he didn't do that. He could have gone back to Ohio where he had a valid license. He could have stayed in Texas and driven at least for a while on an Ohio license. And he had a vehicle that his aunt was providing him. He never testified that he was suspended at any point, that his license was suspended. There's no testimony of that. In some of these other cases, there is testimony, like the one case I cite, there's a truck driver who's reliant on his CDL to make a living, and that his CDL was suspended, and that's why he couldn't work. There's nothing like that in this case. And again, even in that case, I believe that's a 12th district case, even in that case, they rejected the affirmative defense, where the guy's truck driver and his CDL was suspended. So,
How long was there evidence of how long he was in Texas before he was extradited?
I don't believe there was an exact amount of time, but I believe it was a significant amount of time.
And to follow up on that question, is anything in the record tell us why he was picked up? Was he picked up on this warrant, or was he picked up for something in Texas and this warrant appeared? If the record reflects, it's just a question.
I think he was picked up on this
warrant?
case in Texas. Yes, I believe that is in the record. That is true. There wasn't any separate violation of the law. But again, another one that people often claim, like this 5th district case I have here, is that they were incarcerated for some period of time, and he was detained for a brief period of time, I believe, when he was brought back from China, or somewhere in Asia, I believe. But he was not incarcerated for any period of time during this period of question, which is 2012 to 2018. He was asked, can you, I want to make sure I have it right, can you walk, can you talk, can you bathe yourself, can you feed yourself, can you run a cash register? He says yes to all those things. The bottom line is he was capable of working, he didn't work. No specifics, like was said, were given as to where exactly he applied, but surely he could have obtained employment somewhere. Fast food, like was mentioned, run a cash register, something like that. The bottom line is Koudelka was behind, at the time of trial, $18,610.11 for basically 6 years of non-payment of child support. And that more than raises an inference in itself under Collins that he knew about his obligation and in fact intended not to pay, let alone recklessly didn't pay.
Counsel, it's just that the cases that you've cited, it just seems like there's different factors there. Here is an individual, and I agree that some of the evidence indicates he was with relatives some of the time, but he was homeless some of the time. And it makes it sound like it is a debtor's prison.
Well,
That the punishment, is more like a debtor's prison.
and I don't think that's the case, and I don't think that's the state's intention. Whether somebody lists a homeless shelter on an employment application, is that a stigma? I don't know. Do most people even know what, if you just put an address down and don't put that it's a homeless shelter, would they even know that it's a homeless shelter? I don't know. It depends how deeply they look into you, I guess. But I mean, the point is none of that's in the record, I guess. But I think the letters are very interesting that Judge Carr brought up. They show not only did he know about his obligation, he just didn't want to pay. The first letter is from, and they're very telling as to his state of mind. The first letter that Ms. Jenkins, the obligee, received, the mother of the child, she received in November of 2015 from Koudelka, asking Ms. Jenkins to have all of Koudelka's future and back child support dropped. Koudelka stated that in exchange, he would not bother his son or Ms. Jenkins again. So the old quid pro quo. In May of 2016, Ms. Jenkins got a second letter from Koudelka where he simply provided his address and phone number and asked Ms. Jenkins to give that information to her son. In a third letter, this is the most disturbing one of all, to Ms. Jenkins, it was written all in red pen. Koudelka stated that by not contacting him, Ms. Jenkins was, quote, forcing him to go down a cold, rigid path of legal recourse. He stated that option one was he was going to try to get custody of the child in court. Option two was Ms. Jenkins could go to the courts and, again, he says, extinguish the child support obligation. So you can get rid of my child support, or I'll take you to court for custody. The third page was just Ms. Jenkins' address written very large in red pen. I'm sure that was quite unsettling for her to receive that. He even knows, he clearly knows where she's living. He's researching her, it seems. It just shows, like I said, he knew about his obligation. He just simply didn't want to pay. He's asking her to waive his payments. And I would just mention again, in terms of the driver's license, that's not even a prerequisite to holding a job or or getting a job. There is public transportation as well. Like I said, that was rejected by a court. That somebody a truck driver had their CDL suspended. There was. Another, I'm sorry, that was a 10th district case. The 12th district case, there was somebody who he had lost his regular driver's license due to multiple DUIs. Says he actually lost an eye in an altercation, so he's got a physical disability as well. Various other physical elements, as well as borderline personality disorder. All of those, there was testimony that hindered his ability to maintain employment. So again, you had all those things, and the 12th district still upheld the jury's rejection of that affirmative defense that he couldn't pay. So it's a pretty high bar if you want to try to overturn that.
When would there be justification?
Well,
I mean, when would it be sufficient?
I think that's ultimately up to the jury, but you have to take into account the totality of the circumstances and, given, you have to look at that, I think, the amount as well, and the amount of time, the amount of money. Take that in conjunction with, what are the issues going on in this person's life, and what efforts did they make to pay? Because again, the standard on this affirmative defense is that they provided what was within their ability and means. So was there an effort made to make some kind of payment? In this case, it was very minimal. It was a couple $100 that he didn't even do. It was his family that sent it. I think that was mentioned. It was not much considering the overall amount of $18,000. So I think if you take all that, you have to take it all into account. But
Was there a period of time where he did pay consistent? It looks like from 2006 when they agreed to change the amount until 2012. Was there a period of time when he did pay regularly, and then at some point?
I'm not sure exactly all the payments from 06 to 12. This case only focused on 2012 through 18, those 3 two-year periods. So I can't really answer that question, but I assume he was paying fairly regularly if he wasn't having issues.
And counsel, you're on the 10th.
Thank you, Your Honor.
You have just a little over a minute and a half left to rebut.
I just want to clarify a couple of things, because as he brought up, the original payments, there were those multiple payments. And so each time during that 6-year span, when he was homeless, living on the streets, when he would be able to obtain money from family or get it from that, there were some payments that were made. So he obviously was trying. Additionally, in regards to his arrest in Texas, he was arrested when he went to the BMV to change his license from Ohio license to Texas license, which is what was required for the job that he had to come in and do his final paperwork to get that employment in Waco, Texas. They arrested him for the outstanding warrant for this case.
Somebody gave him money, obviously, to pay to get his license transferred.
Yes, and his aunt had taken him there for him to do that, was advancing him with that stuff so that he could convert his license, so he could get the job and get on his feet, so then that way he could maintain that communication. Each time he started to communicate with someone and it started to get closer to a job, he let child support know. When he started working with the employment in China, he let them know that I think I'm getting the job here. Here's where my child support will be coming through. It was not a full blatant disregard for it. He just unfortunately fell on some very significant hard times and was trying to get himself out of that state of homelessness.
Thank you, Council.
Thank you.
Thank you both for your arguments to the court this morning. We will take the matter under advisement, and we will issue a written opinion, which will be sent to both parties as well as released on the website. Thank you very much. Have a good afternoon, and